content writers, and so I just give them my resume, and then they put together the box.
Get started. Hello, everyone. Thank you for coming to our institutional racism in legal systems part 1 in a series discussing criminal justice. I have a few things that I would like for you to remember or know. In the chat right now is a link to the handout, and that also is on our calendar invite. So if you can't find the link in the chat, you can go to our calendar. It is on that page, and you can download the handouts. There's some great links to other materials within it. Please sign up through our calendar so that after the program, we can send you the hour-and-a-half CLE form and the online survey. We will send it after the program. And you can email us at info@fcba.com with any questions or concerns, or you can chat with us or Q&A. Yes, also, for your questions, attendees, please go ahead and use the Q&A box at the bottom instead of chat. Chat can go kind of quickly sometimes, and we don't want to leave anyone out. So if you could type your question into the Q&A, it'll be easier for us to keep up with your questions and get them answered. I'm going to turn it over to Cassie Carter from the Young Lawyers section, FCBA Young Lawyers section. This is a joint effort between the John Rowe chapter, National Bar Association, and the FCBA Young Lawyers section.
Thank you so much, Dana, and thank you for everybody who is joining. We are so excited that you're here today. And for this first installation in our series on understanding race in legal systems. And as you know, today we're talking about the criminal justice system. And while I don't have any expertise, I'm in the commercial litigation group at the Lexington office of Dinsmore and Scholl, but I am super proud to present these 3 panelists who have an incredible wealth of knowledge on not only the criminal justice system in Kentucky, but also just the impact that injustice has in our system. And so on behalf of the Young Lawyers section of the Fayette County Bar Association and the John Rowe chapter of the National Bar Association, I am so pleased to be able to present this important conversation today. Just a reminder, our other panel discussions in this series are going to be on September 10th regarding race and employment, and on October 8th discussing race and housing. And we have some incredible panels scheduled for those dates as well. So I hope that you can join during those panels. I certainly think you won't want to miss them. So for today's discussion, like Dana said, please use the Q&A function, and I see people already have, and Dana is gonna respond to any technical questions, and then we will, I'll try to be looking at the Q&A throughout as we moderate and go through questions. I can't promise that we'll get to every question, but we will do our best to either get to it during the discussion or possibly at the end. We'll just kind of see how that flows. So I have the honor of introducing our panelist. First up is Dr. Melynda Price. She is the William L. Matthews Junior Professor of Law at the University of Kentucky College of Law. Professor Price is the author of At the Cross, Race, Religion, and Citizenship in the Politics of the Death Penalty. Her work has been published in both peer-reviewed social science and law journals, newspaper articles, and literary journals. Professor Price joined the College of Law as an assistant professor in the fall of 2006 after completing her doctorate degree in political science from the University of Michigan. Her dissertation was awarded the 2007 Best Dissertation Award from the Race, Ethics, and Politics section of the American Political Science Association. In addition to her degree in political science, she also earned her JD from the University of Texas School of Law in 2002. While at the University of Texas, she was a member of the Texas International Law Journal and was awarded both the University of Texas Co-op Award for Public Interest Law and the Baron and Budd Scholarship for Public Interest Law. She completed her undergraduate studies in physics at Prairie View A&M University in 1995. Professor Price's research focuses on race, gender, and citizenship, the politics of punishment, and the role of law in politics and race and ethics in the US and at its borders. In 2008, she was awarded a Ford Foundation Diversity Postdoctoral Fellowship. Her host institution was the Capital Punishment Center at the University of Texas School of Law. So thank you, Dr. Price, for joining us today. And she can say any of her other accomplishments later if she wants to. That goes for all of you. Next, we have the Honorable Melissa Moore Murphy. The Honorable Judge Melissa Moore Murphy is a 1998 and 2001 graduate of the University of Kentucky. In 1998, she received her Bachelor of Arts in Political Science and History in the honors program with a minor in vocal music performance. She received her Juris Doctorate from the J. David Rosenberg College of Law in 2001. Judge Murphy started her legal career as a staff attorney for the Honorable Judge Rebecca M. Overstreet. In 2002, she became a criminal prosecutor. For over a decade, she had the opportunity to work on every level of the prosecutorial system. She served as an assistant Fayette County Commonwealth Attorney, assistant McCracken County Commonwealth Attorney, assistant Fayette County Commonwealth, and a special assistant United States Attorney for the U.S. Attorney's Office for the Eastern District of Kentucky. In 2014, she continued her legal career in public service when she joined the Lexington Fayette Urban County Government's Law Department as a senior attorney. At LFUCG, she had the opportunity to advise and represent various departments and divisions, including the Department of Social Services, the Division of Grants and Special Programs, and the Mayor's Opioid Prevention Project, the Division of Police, the Office of Affordable Housing, and the Office of Homelessness Prevention. In April 14th, 2020, Governor Andy Beshear appointed Melissa to the vacant Fayette District Court seat. She was sworn in on April 24th, 2020. Judge Murphy is a member of the Kentucky and Fayette County Bar Associations and the Lexington John Rowe chapter of the National Bar Association. She currently serves as a member of the Board of Directors for the Chrysalis House and a member of the Picard Committee for Academic Excellence. She has previously served as a board member for Greenhouse 17, Interpersonal Violence Shelter, the Lyric Theater, and has been elected parent representative on the Psych Decision Making Council for Meadowthorpe Elementary School. She's married to Danny Murphy Jr. and Senior Assistant Dean of Community Engagement and Operations, Chief Diversity Officer at the University of Kentucky, J. David Rosenberg College of Law, and they are the proud parents of 3 and grandparent of 1. Just as a reminder, Judge Murphy is speaking for herself today from her personal experience and her work history. She does not speak for the judiciary or the state of Kentucky in any of her answers. Our final panelist is Noel Caldwell. Noel is a local attorney in Lexington. He fights for the rights of criminal defendants and victims of police misconduct and other civil rights violations, and those injured by others' neglect across the state of Kentucky. A former prosecutor and government defense attorney, Noel brings an insider's perspective to these cases, helping clients understand how the system works. A cancer survivor and health advocate, Noel's frank honesty assures his clients. He helps them set realistic expectations and consider the options before them. In his first year of law school, Noel Caldwell was diagnosed with cancer. Over the next year, he fought against the disease, guided by a doctor whose frank, honest advice kept him focused on the next steps of the way. Surviving cancer and the doctor's approach to life-changing event had a profound impact on Noel. With cancer behind him, Noel completed law school and started his career in the Fayette County Attorney's Office. He spent almost 3 years prosecuting state misdemeanor and felony cases. Then he joined his father and brothers in the family-based private practice. In that firm, he served as a government defense attorney, representing Kentucky agencies and actors when they were sued by residents of the state. From there, he became a government lawyer himself, working as the executive director of the Kentucky Business One Spot portal. In all his work, he learned the strategies, methods, and legal arguments that prosecutors and government agencies used against criminal defendants, prison inmates, and other victims of civil rights violations. Now he's happy to use his insight into these systems to help the individual criminal defendants, prison inmates, and residents defend their rights and get fair resolutions to their legal issues. When clients sit across from him facing life-changing criminal charges or injury, he remembers the doctor's approach and uses that same frank honesty to guide clients through their own struggles. Noel has been representing criminal defendants and helping individuals file civil rights and personal injury lawsuits for multiple years now, working in both state and federal court. He brings his unique insight and empathetic approach to every case. Thank you all. As you can see, we have an outstanding panel today who are incredibly qualified to talk about the issues that have kind of built our criminal justice system, not only in the state, but also nationwide. Do you panelists have anything to add before we hop right in?
I'm sorry, Cassie, could you repeat that one more time?
Do you guys have anything to add before we hop into the questions?
Oh, no. No, I guess I could make a few quick comments because one, I thought that's what I was supposed to do, so I prepared just a few comments. One is that I have reached the age where I want to start taking the dates out of my bio. That's the first thing. I think that it is important to remember that as we have this discussion that I'll speak for myself and not for Judge Murphy. It's important to remember that as we talk these issues of institutional racism, we're also talking about the lived and embodied experience of Black lawyers as they walk through the halls of justice, as they were. And I can tell you stories about being in court in a suit and being asked if I was there because one of the defendants was my relative, even when I'm standing talking to other lawyers. I can tell you stories about my own child who's 10 and his expressed fears of engaging with law enforcement. But there is a need, I think, at this moment where we are having a lot of discussions for some real honest reflection about the things that we already see before us in the practice of law. And I've mostly done work around the death penalty and particularly around juries, capital juries. And there is one of the things that we have been talking a lot on the task force that I'm on for the mayor on law enforcement and justice accountability. I forget the exact name, but that's a loose definition, is the role of discretion and how at every point where there is discretion, we can see systemic bias. And even with that, we know that taking away discretion also is just as harmful to people of color as they enter the judicial system. And one of the things that I think we can all be a participant in dealing with in the challenges of institutional racism is in talking to young activists, college-age kids, that many of them no longer see law as a pathway to fight for justice. And how do we get back to the idea that the law is a noble profession for which the people like Judge Murphy, like Noel Caldwell, can be in it and fight for the good and for what's right and to advocate for a better society. So those were the basic comments I had, and I'd be happy to answer any question.
And that kind of leads us really into, we wanted to kind of break this down, if you can see the link. We want to break this discussion down sort of into what we see as some pre-trial issues, trial issues, and then post-trial or post-conviction issues. And so kind of starting the conversation looking at those pretrial issues, I wanted to maybe start off with a bang and just say, you know, there's conversations going on all around the country about defunding the police, taking away some of that discretion or adding to the discretion. Is there room in our criminal justice system for that measure, or do you see kind of any alternatives for modern policing or modern law, as you were saying, Professor Price?
I'm gonna start just because when I was reviewing that question, and I was also looking back at my working at the city of Lexington. We've discussed this, as Dr. Price says, she and I both get to serve on the mayor's task force for law and justice and accountability. And one of the things when we're talking about defunding the police, I think one, it sounds so harsh, the language of it, but it's not necessarily about defunding the police. It's about allocating resources to where we know the need is. And so often we have looked at our community as just being a crime and punishment, and that's just what we have to do. But a lot of the crime that we see, or what could be diffused from being crime, are things that are drug addiction, homelessness, those who are addicted to alcohol, mental health issues. So if we're looking at how we can reallocate money that we have typically has gone straight to the police for them to do what they have been doing, but they're not necessarily trained to be social workers. They're not trained to be mental health advocates. So they get a phone call to go down to an area of town, and they're met with someone that has all of these other issues that then becomes a criminal issue. And so I think, yes, there's definitely room for it. It's just whether or not we can find in ourselves that we have to acknowledge that the world that we live in is completely different than how we have all, I guess, maybe grown up in. I think Dr. Price has a good story. I think she went to a high school that trains police. Like, and just that, the thought of how that high school, how it, I guess, when we're looking at the training of police, that training has completely just completely changed to now meet the needs of our citizens. But has it truly changed? And are we cranking out social workers? Are we cranking out therapists that are able to go out on calls? And so what I was going to bring up is, from the city of Lexington vantage point, the Division of Fire and Safety brought in a community paramedicine program. It was originally a grant-funded program that we got from an opioid addiction grant. And so I had the pleasure of working through that with them. And when you're looking at the money that the fire runs were going out to deal with people who had severe mental health issues, who were using fire safety, mainly fire safety runs, because they couldn't make it to their doctor's offices. So they're asking our EMTs to come out and check people's blood pressure and things like that. But when we were able to finally divert funds to have a social worker on the truck with our fire department, when we're having a mental health professional on the EMT run, the number of calls was dropped, because then they were able to funnel those people to the correct resources. And so those are the type of conversations that we need to be willing to have, that it's not about getting rid of the men and women that do a great job in our police department. It's about making sure the resources are there to protect our community the best way possible.
And just taking a lead off that, and I think Judge Murphy said it perfectly, the defund police is more of a movement for reallocation towards appropriate resources, just like she just said. And that can be misinterpreted to say, hey, we're getting rid of the police altogether. And I think one thing we're seeing where allocation of funds are going, we have seen a modern militarization of our police force. We've got SWAT teams running around in fatigues and Army gear, what appears to be Army gear. And I think that creates a mentality of us versus them. And we do have a lot of young men in the past 15 years that are joining the police force that are coming back from places like Iraq and Afghanistan and so forth. And it's turning into an us versus them mentality. And we're seeing, extreme unjustified shootings and so forth based off a lot of militarization of our military, rolling in with military vehicles and things like that. So it's just like Judge Murphy said, it's an effort for reallocation towards appropriate resources, and an effort And one thing I do want to commend the Lexington Police on is a community policing, so forth. I recently saw a story about Officer Brandon Moravchik, who I've known for years, where he's assigned a role to go out and be this community police partner, where you're meeting and discussing with the neighbors and so forth. And so more of an effort towards a reallocation and developing more of a community policing theory rather than an us versus them mentality. I think it should be part of the reallocation.
Forgot. Kind of staying on that theme and talking about what the police are legally allowed to do and what your rights are as someone who has either been stopped by the police or pulled over or approached by the police. I want to talk about a little bit about Graham versus Connor. And I came to this case, like I said, I am not a criminal litigator in the slightest, but I am a big podcast listener. And so anyway, Graham versus Connor came to my attention through a podcast that I've linked in the discussion. But for anybody who doesn't know, it was kind of the case that changed how police were to, and the court was to look at police conduct. And so I can let the panelists discuss that a little bit more, but it definitely has gotten a lot more publicity lately, and just how juries are also supposed to look at that police force. So can you guys discuss the intentions of Graham versus Connor and how it's actually used by police and juries in practice?
Yeah, I'll jump right in on that. Graham versus Connor established the objective reasonable standard for law enforcement in regards to excessive force. And so it turns it into a question of, when you see a case of excessive force, say in a civil rights lawsuit like we do here, and that it effectively leads on to the standard of what we call qualified immunity. It presents a question of, objectively, what that police officer did, was it reasonable? And that is such a broad standard, and a standard that is protected, in my opinion, law enforcement, since qualified immunity was first discussed by the Supreme Court in the late 60s. And it's created a shield for law enforcement. And I think there's been a ton of talk and discussions, especially since George Floyd, about qualified immunity and getting rid of qualified immunity or limiting qualified immunity. And Graham versus Connor is part of that discussion, because it is what established this objective reasonable standard when you're analyzing excessive force cases. What we're getting in a lot of these excessive force cases, and this leads on to a broader discussion, but we're getting police investigating police. And for instance, I'm involved in a case right now where an individual was shot and killed by the state police, and Kentucky State Police has a shoot team that they send in to investigate every shooting in the state. This case was presented to the grand jury. It was not indicted. And when we got the file that was presented to the grand jury, they entitled their investigation to the grand jury, "The Attempted Murder of a Police Officer." And basically their whole presentation and grand jury presentation went off that what that police officer did was reasonable under the circumstances. And so we're seeing Graham versus Connor discussed in the realm of qualified immunity, and arguments moving forward on what this police officer or a police officer did. Was it objectively reasonable? And when you have police investigating police and the criminal justice system looking at it, overwhelmingly, we're getting the answers that it was, when in fact it was not.
I think there's a discussion to be had, not just about qualified immunity for law enforcement, but about the ways in which the tradition of immunity for all persons in the criminal justice system impacts the ways in which the ability of citizens to really change how some of these practices take place. There have been several important cases in the last 5 years, I think, on prosecutorial immunity. And we don't want to create a situation where, when doing their jobs, state and city officials are constantly hesitant to do what is right because of fear of suit. But also, we know that we have created a legal system where suit is the ways in which you are able to make large systemic changes faster than just the sort of call of individuals who work in those systems for those changes. So I think the question that we're asking ourselves about law enforcement immunity is one that lawyers should also be thinking about as well, and our role to play in how we think about the enacting of justice.
And from my understanding of Graham versus Connor and how juries are supposed to look at police conduct and just what a reasonable officer would do at the time, and looking at just that moment, how do you think that that standard will be applied to kind of our current political, social environment, and the cases that are coming up now through after George Floyd and with Breonna Taylor?
I think we'll have to see, in part because many of these cases of police-involved shootings, if they make it to the grand jury, rarely make it out of grand jury. And often when we go to trial, you see in many locations change of venues to move them out of the cities where they have taken place, where there's a more diverse jury pool, into adjacent communities where there may be less diversity in those jury pools. And if you add in the compounding impact of things like felony convictions, the inappropriate use of peremptory challenges, the likelihood that there will be people of color on those juries, even if they stayed in their locale, is also relatively low. But the number of people who have been, whether it appears that there will be some sort of legal process or trial to come out of the cases that are happening right now, I think will be more telling than what we have seen in the past.
Yeah, that's exactly what I was going to say. I think it's a wait and see approach, because now we're in an environment where people are calling for the investigation of the actions by police and calling for them to be charged. And I think it's a wait and see approach on how the jury system is going to react to that and whatnot. But prior, I mean, it's rare that we've seen officers charged and how the jury is going to react. So I agree with you that it's going to be a wait and see approach and so forth.
While we're kind of talking about juries, I'm going to skip around a little bit. What part do you think our current juries play in some of the inequities that we see in the criminal justice system? And I want to give you guys an opportunity just to talk about some things that maybe you've seen firsthand.
You're the first-hand people. I'm the person who reads.
Okay, that's what I was going to say. I was going to say, Dr. Price is going to say it's us.
I read the transcripts of what you did later, yeah. So you guys should take that.
Well, I will say that I have seen, and this is just my experience, of course, as mainly as a prosecutor, and taking the time to do true good voir dire and knowing what type of juror you want on your panel, and that training that you may get. I think it all depends on how you were trained. And I'm not doing this for brownie points, but I was trained by Kimberly Henderson Baird, but mainly also our current Commonwealth Attorney, Luana Redcorn, and I know she's an attendee right now. And so one of the things is making sure that any challenge that if we had someone that we were striking because of race, that it was a true reason, and race was not a basis to strike them. And I don't know, I can't speak for the full Commonwealth of Kentucky, but I don't know that everybody got that type of training. I practiced in two separate spots. When I got to Paducah and practiced at the Commonwealth Attorney's Office, there wasn't any type of training that showed me how I should go about voir dire process. But I will also say, and this is what I have experienced on a personal basis, is that many people, especially Black individuals within our community, do not want to serve on juries. They have no desire to serve on juries, one, because they don't trust the system and they don't think it works fairly. And we also have to look at the economics of it. You get $12 a day to come and sit for a full day. However, they're losing their salary from their job. They have childcare issues. They have other things that are pressing. And so I always get the question, how can I get out of jury service? And I'm like, if I hear one more person tell me that, and I'm like, no, I said, the system does not work if we all are not willing to be invested in the system. I get it. It's not the most, it's not the best system, but it is the system that we have. So how do we make it better? But we can make it better from working within. And so those are the things that I've seen personally that, but I think that we do need to start as a state looking at the payment for jurors, what it looks like for someone to take a full day to sit in and be interested in what, one, sitting in judgment of another individual, that this person deserves their fair day in court. And it's not somebody that is thinking about, I've got to go pick up my kid at 5 o'clock, so we better get out of here by then. So all of those things come into play, and that's for a criminal jury as well as a civil jury, but mainly for our criminal jury, we have to understand what's at stake when we have individuals sitting in that box. So I have seen it on both ways, that we have to be sure that we are picking jurors, and that any strikes that we're doing, that it is not on the basis of race. Again, I can't say that everybody has that training and that belief, but that's my experience. So,
and I'll feed off what Judge Murphy said. We were fortunate to be young prosecutors together over a decade ago. Can you believe that, Judge
I know,
Murphy?
stop it. I'm with Dr. Price. We're not talking about years anymore.
I know.
Right?
But I was very fortunate to have been trained very well also in regards to jury selection. And I think that's just a basic practice tip is, whether you're prosecuting or defending, is really, really digging in on that jury list prior to a trial, and so forth. From a defense counsel perspective, and I think many on this call would agree with me, it's a reality as a defense lawyer when I have a young African American client who's going to trial in a rural county, that we have to have a discussion of, hey, we've got a good case, but our jury pool may not treat young African Americans very well. And no matter what type of case we present, you could get slammed on this. And that's a real discussion. And I'm not in their shoes and I'm not sitting there, but that is a frank discussion that we do have to have. I just had one last week with a Hispanic individual that we believe we have a very good case, but it is in a very rural county. And with the environment towards Hispanics and so forth and minorities, he is scared to death to present his case in front of whatever potential jury might sit, no matter how much jury selection we do. But it's a factor, and it's a real factor that I think every defense attorney on this call would agree with me, that you have to have that discussion, that unfortunately, no matter how good your case is, you've got to look at where you're at, what part of the state, and what biases may inherently be in that area of the state before you go to trial.
And I'm piggyback, and I know you have that as one of the questions, but we also have to look at how felony convictions and mass incarceration and things have taken away the jury pool of many African Americans within our state. And so therefore, and that's the reason that I'm so passionate when I hear Black folks tell me that they don't want to serve. And I'm like, look, there's already a whole exclusion of Black individuals serving on the jury because of these other issues. So I have always said this, and I recognize that the law is the law, but I've said this, publicly. Once a person has served their time in the prison system, there's no reason that their jury service should be completely taken from them. There's no reason that their right to vote should be completely taken from them. They are now back in our community, and if they are in our community, they should be fully active citizens within that community. And being a true citizen, being a part of a jury, having the right to vote, all of those things is being an active citizen. And so we have to be honest with, especially in the state of Kentucky, I think, and I never know the numbers, but I think African Americans were about, 14% of the population, 15% of the Commonwealth of Kentucky. I could be wrong. Dr. Price probably has it. She knows it because she's an academic, so she knows it. I know in Lexington, we're about 13 to 14%. And so when you exclude for those other reasons that honestly have no bearing on whether a person can truly sit in a jury and listen to the evidence and be fair and impartial to both sides. A prior conviction shouldn't take you from that, and so I think those are conversations that we have to have going forward if we're trying to do good work in reforming our justice system.
So I use Google like everyone else. 8.5%.
8.5%. Wow.
In the state, I don't know what percentage in Lexington. I think you make a very good point. And I think one of the things that people often miss in the question about whether or not people with previous felonies should serve on juries is there's no reason to believe they would be any more lenient than anyone else. And the same is true actually for African Americans. In order to get to the jury, they have to be willing to express intention to implement the law the same way the other juries who sit on that, the other jurors who sit on the jury do as well. But one of the things we know, at least from capital juries, is that the mere presence of African Americans substantially reduces the likelihood that the defendant will get death over life. They would get life rather than death by a substantial amount, particularly if there's one Black man, even if they all hold the same views, because there's something about the presence of other Black people that can be humanizing for the defendant. I also think we need to talk about not just felony convictions, those people who have been convicted of felonies, but also people who are in networks with people who have been convicted of felonies, because at least in the Texas juries that I have studied, you often will see people struck because Black people struck because they have friends or relatives who are either undergoing criminal proceedings and or are incarcerated or have been incarcerated. And I try to tell people, if you were to put me, I would be struck from juries based on that. Right? A person who has who I see myself as tremendously fair and has been a lawyer and has been a law professor, I would not be able to sit on a jury under those circumstances. Now, I have both relatives who work in prisons and relatives who have been sentenced to prison, but none of that mitigates. So we have to think about the ways in which other kinds of attachments or associations with Black people to criminality then again further reduces the potential jurors who will be present, again with no understanding or empirical basis for believing that those people would be more or less lenient than we think. And we have other examples of leniency in given communities. Like there are some communities where it's very hard to charge people with marijuana convictions. There are some communities, a public defender in Atlanta told me once that if you have a young Black male and you have more than 5 Black women over the age of 40, you're never going to convict them of a street level of a personal use amount of drugs, right? There are all kinds of ways that we know that there's built into the system certain kinds of leniency when people are present, and that's the way juries should be. They're supposed to be there to implement the law, but also to soften the hard edge of laws that seemed great when they were in the minds of the legislature. And if we don't have enough diversity in those jury pools, then we're never going to be able to have that kind of fair mediation of justice between citizens and the written law that we expect from jury decisions.
Yes.
On those topics, in the handout, there is a link to a 2018 survey that talks directly about what the panelists are talking about here. it showed that 63% of Blacks have had a family member incarcerated versus 42% of whites. And you guys have already talked a lot about how this view and things happening in communities of color have an impact on juries. And I also wanted to point out, also in the handout, there is a case that just came out from the Sixth Circuit, United States versus Jackson in 2019, talking about veneer challenges and the statistical evidence needed to challenge the constitution of a grand jury and the jury pool as a whole. And I thought that it was interesting in that case how few, then this was in Tennessee, so their way of qualifying the jury pool is different, but how few African Americans it had as qualified for the jury wheel. And I think that definitely goes along with what Judge Murphy was saying about how in Kentucky, if you can't vote, then you won't be considered as part of a jury. So thank you all so much for those comments. Let's talk a little bit about challenges, not only veneer challenges, but also Batson challenges. And do you feel that Batson is doing the job that it was created to do? Do you see those challenges? Are they coming up? And is it doing its job?
I want to go first and state the unpopular opinion before you talk to two trial lawyers. So we have been wrestling with Batson decisions. So we go pre-Batson to Swain versus Alabama for decades now. And my favorite, like most Black kids who grew up in the wake of the Civil Rights Movement, Thurgood Marshall was a lion of what it meant to be both a lawyer and to be a judge. And he mentions in his opinions in these cases when he was still in the court over and over again, how difficult it is. Batson relies on the instincts and intuitions of lawyers to understand who should and should not sit on a jury, but also instinct and intuition, racism can be a part of that instinct and intuition. And so I keep saying we have to really rethink these, but lawyers, defense lawyers, prosecutors, civil lawyers on both sides, all hold on to the idea of Batson as such an important tool. And I believe them. Again, I have read the transcripts. I've seen the receipts about how important it is. But the data continues to show over and over and over again that overwhelmingly this one particular tool is used to remove people of color from juries at an overwhelming rate still. They just redid, so underlying Batson versus Kentucky, in that case, they actually spent a lot of time talking about Dallas, the city of Dallas, and they redid, the Dallas Morning News had done a report and gone through and looked at how many Black people have been removed from the jury in that county using peremptory challenges. And of 400, of 450, something like 420 people, somewhere in that range. And they went back and redid it again in the early part of the last decade. And what they found was the same numbers, roughly the same amounts of Black people were still being removed using peremptory challenges. And so we just have to ask the question, right? How are we so wed to this one particular tool that we that the amount of discrimination that it allows for is actually worth it? Because overcoming a Batson challenge is not very hard. And in my book, I quote a lunch I had with Judge Paisley when I first moved here. And he told a story about how, he said I could quote him, so I feel free to tell this story, about how they were in court and a lawyer comes up, a juror is dismissed by the prosecutor, and the defense attorney says, I challenge this on Batson grounds. And they come to the bench and they're like, why are you challenging this? And the prosecutor said, and the defense lawyer says, because this person is Black. And the prosecutor says, that person isn't Black. And then the lawyer says, I know a Black person when I see one, right? So even in our understanding of who the people are who are subject to these challenges, there is conflict over what we're doing. And we just have not found the ways in which we just keep circling around. So we've moved from the jury voir dire to the jury pool. And we've moved from the pool to thinking about all in the sake of how do we preserve this particular tool. So I'm gonna start with the unpopular opinion. Now go, trial lawyers. Tell me why I'm wrong.
Go, Noel. I'm not a trial lawyer anymore, so I'm gonna let you roll.
I can just speak from experience. I've never won a Batson challenge, and it's just like Dr. Price said. They've made it so easy to overcome, and it's a pretty simple answer. But in my experience, I've never won a Batson challenge, and I agree with Dr. Price. If you look at the statistics, it is a tool that has been used to remove African Americans from the jury, and never won one.
I don't have anything to add, so.
What do you think the race of the attorney defending and prosecuting the case plays in the jury's opinion of the case, in the judge's opinion of the case, and maybe even the outcome?
Well, I have an anecdote and I have a story. And, when you look at a community, especially like Lexington, and even other communities, most, I won't say most, but Black individuals know others. And so so I believe, yes, it does have a role in it, and it just does. And so my story is kind of a lighthearted one. I had a church member who was in the jury pool, who knew other people. And so all of the Black individuals kind of gathering together. And when she saw that I was the prosecutor, she stood up and was just like, well, I know Melissa, and I know Sister Melissa, and I know that if she's prosecuting, then he must have done it. And, and literally we're like, oh no, don't say it. Don't say it in front of all the jurors. But I mean, it won, and this is kind of a more of a community thing. And this is for Black individuals when they see, because there's not many of us who are lawyers in the community, not many of us who have chosen the prosecutorial field, when Black jurors see a Black prosecutor or even a Black defense attorney, it is kind of that unspoken, they look and they're like, I'm with you. And it's not always, it's not a across the board, and I can't say that it's for everyone, but there is that there. And so that I have seen it multiple times, that the especially if it is a 60 to 70-year-old Black woman that's on the juror who thinks that she's my grandmother, she's gonna look at me and she's gonna be like, I see you, honey. I mean, like it's just there. And so that's just a personal story of what I've seen. So I know it does play a role for jurors when they see that.
A good lawyer is better than no lawyer. And so I come from a state, I have a license from a state where we do not have the kind of developed public advocate system that we have here in Kentucky. As a matter of fact, when I was in law school, some of them came down to begin working with lawyers there. And what you really hope for is that the lawyer that you have is a lawyer who really will do all that they can to represent you. But I do think it's just sort of important that if you find yourself representing a lot of defendants who are of a different race than you are, that you work hard to make sure you have the cultural competency to see things like, for instance, we know from psychological studies, it's very hard across race to read remorse. So for instance, when you have a Black defendant, the white juror's perception of remorse is often, it looks like anger, right? So what are the psychological cues that may be misread by juries so that you can soften them and work with your client in order to make sure that they are not being interpreted in a way that works against them, but also that's inaccurate. And that's the work of the lawyer to do that, because you have to present the best case that you can, that you are treating your clients with the same consistency that you treat all your clients, right? That you know how to talk to families. And this is not just across race, it's also across class,
Yes.
right? Do you know how to break things down and explain them so that people feel like they are fully informed about the choices that they are about to make? That's not just for criminal lawyers, but also for civil lawyers. When you're entering into when they're entering into some sort of agreement about a personal injury case, do they fully understand the meaning of that agreement and why it might be optimal as opposed to trial? That the idea, like if I were a Black person and I went to a lawyer and the lawyer said, I only see people, I don't see color, I just see people, I would find another lawyer, because the world sees color. And you need to understand, for instance, we know in civil cases that pain is something, the experience of pain is something that is under recognized in Black patients in healthcare. In healthcare cases, you need to understand that race is a factor, and that you need, and how it operates in the context of not just the society, but the claim in which your client is attempting to bring.
And I know Noel may have but I'm just to piggyback on that, and what you said is just also the cultural competency, and that's the reason that I believe that every office, especially a public facing office, should represent what a community looks like and have diversity within it, because you understand and be culturally competent to represent. So as a prosecutor, as a former prosecutor, having victims that were Black victims that came into the office, understanding the lingo, understanding conversational, that other folks may not. In one story, we had a victims meeting, and this was a domestic violence case. And the victim says, I don't even know why he would do this, because I hadn't even seen him in a minute. Now, I, as a Black woman, knew that when she said I hadn't seen him in a minute, she meant a very long time. But the white victims advocate, and she admitted it, she thought that it was a true representation of time, that it was in close proximity. And so that seems very small, but being able to relay that conversational piece to a jury to understand fear, understand that there was this disconnect between the victim and the perpetrator, those are all important things, and you have to be able to relate those things to your jurors. So yes, it does matter. I guess at the end of the day, Cassie, that's the answer. Yes.
This also can be tied into race and class and age. I always like to give an example, the example of during the trial of the man who murdered Trayvon Martin. His friend testified, and they asked her to read something in court. I don't know if any of you I watched this intensely, and some of you may remember this as well. And then the opposing counsel tried to paint it as if she was somehow illiterate and didn't understand. And the truth is that the thing he asked her to read was written in cursive, and most children aren't taught cursive in school anymore. So what she was saying was, I cannot read this piece of paper that you have put before me. It wasn't that she couldn't read, but she couldn't read cursive, so therefore did not understand the report, the written police report that he was asking her to read. So even simple things like that, where now you have a young black woman who's painted as somehow illiterate or lowly educated. That young woman actually spoke 3 languages. But she's being painted this way because you didn't understand the nature of who she was as a whole person, as a witness.
And I, just as a personal comment, I think that it's sometimes hard for lawyers to admit that maybe we don't know our client or our client's story as well as we would like. And so do you have some tips or some things that we can do as lawyers to help us to get into the background, the community, the culture of our clients?
I know from my perspective, is, and I've been very fortunate to have a father that was a lawyer and a former prosecutor and defense attorney, but also worked with Jerry Wright, defense attorney, who spent 25 years as a police officer before he became a defense attorney, and been very fortunate to learn from them. But what I've learned and what I utilize is a very empathetic approach, and I know we hit on that earlier. But you have to take the time to listen to them. You know, there's times where they want to be heard, and you have to take the time to call them back and meet them in your office, meet the family. I mean, there are a lot of families where it takes, you know, the old saying, takes a village to raise somebody. And so we really try to take this empathetic approach, get to know them, let them know we care and we have their best interest at heart. And then we try to demonstrate that on every level. But it to me is vitally important to get to know your client, and be empathetic of where they've come from and the situation that they're in. And you got to take that time, because if you don't care, then you're not going to care about the first offer you received to plead guilty and work harder to get it to where it's supposed to be. And so there's a human aspect of it, to have those relationships, to be able to understand them and to communicate with them. And criminal defense, and I think a lot of the criminal attorneys that are on here would agree with me, the clock never stops, you know, and you got to be able to answer that phone at 9 o'clock at night if they're wanting to talk, and and it can stress you out. I mean, but to me, to really give the best representation possible, you gotta have some empathy. You have to understand and listen to them and communicate and involve the family when they're there.
Dr. Price, we can't hear you.
Can you hear me now?
Yes.
Okay. We tend to emphasize the experience of African Americans because they are the larger population of people of color. But I have a colleague at UK whose name is Rusty Barrett, who might be worth speaking to this group as well, who talks about the linguistic differences. He's a linguist and he studies indigenous languages in the southern cone of Mexico, Central America, and the northern part of South America. And one of the things that we are experiencing now is that many of the people, the immigrants who are coming now, Spanish is not their first language. And people see a person and your passport may say, or your birth certificate will say Mexico, and they begin speaking Spanish to you and believe that you'll fully understand what they're saying, which may or may not be the case. So I think you have to do exactly what Noel was saying, which is to keep talking and listening. And one of the things you should be listening for is whether or not the language that you are asking the person to communicate in, have we fulfilled our responsibility of achieving justice for that person by just bringing in a Spanish interpreter where they may actually speak Quiche, Quechua, or any of the many indigenous languages that those people are bringing into the United States. So there's also a question in the chat box, Cassie, in the Q&A box.
I must have missed it.
It's about elected judges. Given that Kentucky elects its judges and prosecutors, what can you say about the importance of voting in state and local elections in the efforts to address structural racism in our criminal justice system?
Megan, that whole question could be a whole nother panel.
Yeah.
Well, first and foremost, I think that we all have to be cognizant that local elections, I know we always give much attention to our national elections and to our statewide, but your local elections is what's going to affect your more of your quality of life in your day-to-day activities and in what your community will, in essence, look like. I think you have to know that, first of all, we've got to figure out a way to diversify those that are going to run for office. But there's barriers in that. And those barriers are, yes, they are those that are compounded by race, but there's an economic part of it. And so it takes a lot of gumption for someone to say, especially that does not come from a legacy or have a monetary basis, to say, you know what, I'm going to run for office. Especially in a place like in Fayette County. Fayette County is, for judicial races, it's a county-wide race. And so how do you touch this entire county of people? So that is, like I said, that is a extremely, but it's very important. It's very important that we recruit and we make sure that diversity of thought, diversity of appearance, diversity of our cultures, diversity of ethnicities and races are all represented in all of our public offices. And it should be important to our community to have that. But we've got to get people out running for those offices. And, I'll stop there.
Well, you started there, right?
I know.
You are living what you preach.
Yeah.
I think that for a long time, in part because the sort of civil rights advocacy structure was really focused at the national level, that a lot of the attacks on mass incarceration were also focused at the national level. So the impact of things like 3 strike rules, which are in the federal and in many states also adopted. A lot of policy from the federal level was sort of drifting down, particularly in the war on drugs. But I think in many places we have seen a really sharp turn to the local. And where we have seen the election of what are now being called reform-minded prosecutors in many cities, a challenge of at the mayoral levels. Mayoral races have been much more dynamic in cities where we see a call for greater attention to questions of social justice and how community dollars are spent. And so this particular trend will last for a while. And what we hope is that as people begin now to pay much attention to one office at the local level, that will be impact a more focused attention on other kinds of local elected officials, because the